Frustration is not a valid reason for me to deny a motion to compel.
This morning, the plaintiffs took a deposition in this case of a third-party witness, and it was entirely based on this false narrative argument.
I'm sure everything you just said was very important, but the most important thing to me was about a deposition taking place.
I thought you would like that, Your Honor.
I'm not entirely sure.
Uh-oh, looks like the town's attorney doesn't have any cases to cite to, nor does he have a unibrow.
Your Honor, for the O'Keefes, we have Attorney Mark Diller. For CNC Hospitality, we have Attorney Lincoln Rose. For Defendant Waterfall, we have Casey McCaffrey. For Defendant Reed, we have Attorney Sarah Shipley, Attorney Charles Waters, and Attorney Aaron Rosenberg. And Your Honor, we do have counsel for the town of Canton, Attorney David Corian.
Well, here we go again, another Karen Reed discovery hearing, and we have a new face here. This is the attorney retained by the town of Canton. Let's watch.
The motion seeks to compel document, and the subpoena was met with what you characterize as standard Rule 45 objection. Your opposition appears to be characterized based on three reasons: scope, relevance, and an ongoing internal investigation.
During civil cases, which are different from criminal cases, the parties will make discovery demands on each other. If a party refuses to produce certain documents, a motion to compel is filed. That means that the requesting party asks the court to intervene and either mandate that the documents and information be produced or mandate that they don't have to be produced, and that's where we're at right here.
Let's talk about the last one first, the internal investigation. And Ms. Reed's attorneys cite to the Boston Police Superior Officer's case and a couple other cases. So why are those cases not on point?
Well, Your Honor, I believe those cases mainly spoke to whether or not information was discoverable.
Karen Reed's attorneys made requests for documents and information relating to Sergeant Goode. Recall that Sergeant Goode was at the Canton Police Station when Brian Patrick Higgins, the murderer of John O'Keefe, walked in at approximately 1:30 in the morning. Recently, it was discovered that he was entangled with Michael Proctor with regard to sending crude text messages.
Cunt.
And there's been an internal investigation, and old Sergeant Goode has been on paid leave for over 6 months now.
I think we're not saying that ultimately these materials wouldn't be disclosable, and frankly, we think most of them would be a public record. We're just asserting that as a practical matter, we're concerned about the impact that producing these records could have during the pendency of an investigation.
Specifically, Karen Reed's lawyers want any disciplinary actions, records, and information relating to Sergeant Goode.
But they're not the key subject of any argument or case or controversy in the instant action.
Is your objection based that they've not considered public records at this time?
Depending on what they could, there'd be probably an exemption to an ongoing investigation for a public records request, but at the close of the investigation, which we hope will be soon, I mean, this has gone on far longer than we anticipated. We're just during the pendency of it, we don't want to impact or unnecessary, we're still gathering witnesses and interviewing people. We don't want aspects of the investigation to be disclosed. We expect hopefully the investigation be concluded in the upcoming weeks. We just don't understand the fervor or the desire for these records now.
Is your office doing the investigation?
No, there's a third-party investigator that the town has retained.
What's the harm? How's that going to negatively impact the investigation?
Because we don't want recipient witnesses to be available of internal correspondence and the materials we have regarding the investigation until we've had a chance to interview them.
Check out the town of Kansas attorney using big words, percipient. All that means is someone that actually witnessed the events. I'm not sure the argument he's trying to make is going to be valid at all. Basically, all Karen Reed's attorneys want is any disciplinary records with regard to Sean Goode, and they haven't produced them.
How many people are left to be interviewed?
I'm not entirely sure.
Wouldn't you need a little more support for that argument to have some factual basis that there are other people to be interviewed? And tough for me to just accept that blanket claim.
I unfortunately don't have more specifics to give the court today.
But did you try and get them?
You can't. It's my understanding too. Typically, I believe most of these are also
Humana, and this is no surprise with regard to the diligence of the attorneys in the town of Canton and in Norfolk County.
Ongoing, investigations develop and modify as they proceed. But I don't have a current potential future witness list for the investigation before me.
What specific case or statute would you like me to look at to support the town's position?
We don't have one specifically, Your Honor. It was just more of just as a practical matter. The town just wanted to express its concerns about impacting a current investigation while we're...
Uh-oh, looks like the town's attorney doesn't have any cases to cite to, nor does he have a unibrow.
We're conducting it.
All right, so let me ask Attorney Rosenberg.
Well, Your Honor, I actually think it's relatively narrow. It seeks basically two categories of documents.
There he is, Karen Reed's Jewish lawyer, Old Rosenberg, arguing his position that the documents and information that he's requesting with regard to Sergeant Goode's disciplinary history are extremely relevant to a case for which you're actually claiming the town failed to properly supervise, retain, and hire its officers. Let's keep watching.
Basically, the disciplinary record of a single town employee, Sergeant Sean Goode, as well as communications between Sergeant Goode and a number of highly relevant witnesses to this case, and Michael Proctor, who obviously we've talked about before.
So you want records about his employment, you want records about discipline, and you want communications between Sergeant Goode and others. Tell me the nexus between the communications and the disciplinary category.
Nexus is just another fancy legal word for connection.
There was an investigation conducted into Mr. O'Keefe's death. That investigation led to Ms. Reed being charged and prosecuted. That investigation is at the core of the plaintiff's two main claims against Ms. Reed. One, it's all of the evidence, or nearly all of the evidence, that they rely on and will rely on in support of the wrongful death claim. Two, they have intentional infliction of emotional distress claims that are based entirely on this idea that there was a, quote, false narrative about that investigation. Sergeant Goode was one of the first participants and helped to begin that investigation. This morning, the plaintiffs took a deposition in this case of a third-party witness, and it was entirely based on this false narrative argument and the idea that what Ms. Reed has said about this investigation, of which Sergeant Goode was one of the first officers involved.
That's some breaking news. A third-party deposition has already taken place, and here we have attorney Mark Diller. He represents the estate of John O'Keefe in the first lawsuit that was filed.
We're talking about a record of one employee. I struggle to see how that's particularly broad. If I was asking for all of the CPD records during a long period of time, I would understand, but I don't think there's a significant burden here. And I understood the town's objections really to be this issue about the ongoing investigation. One is not a legally recognized objection to a subpoena in a civil case, but I also offered to counsel that we would consider confidentiality restrictions during the pendency of the investigation. Even though I don't think they have a legal argument, I was willing to consider that.
Very smart move by Karen's Jewish attorney. He's basically saying that just because there is an ongoing investigation, there are no legal grounds for the town of Canton to not produce the documents relating to Sean Goode. And Rosenberg offered to have a confidentiality agreement cover any documents and information produced with regard to Sean Goode's disciplinary history. Very smart by Rosenberg.
The town hasn't proposed any. Instead, they just refused to produce based on this objection that has no basis in law.
I'm sure everything you just said was very important, but the most important thing to me was about a deposition taking place.
I thought you would like that, Your Honor.
So let's go to the specific request. Number one, everything concerning any disciplinary action of Sergeant Goode. How is it not overbroad? Any disciplinary action.
If there's a file for Sergeant Goode, one of the first officers who showed up at the scene, and it has 5 disciplinary records or 5 complaints, if that's over the course of 15 years, that's not a burden on the town to gather and produce that file to us.
How is a disciplinary matter 15 years ago relevant?
But let's say there is a history of complaints and discipline or other things like that that suggest the types of things that Ms. Reed has claimed time and time again occurred in this investigation, that would certainly be relevant to her defenses.
Rosenberg's 100% right. You need to have every single disciplinary complaint lodged against Sean Goode, and it can't be that many. We know that these cops are a bunch of dopes, and probably they do have a bunch of complaints, but in reality, how many complaints can one officer in the town of Canton actually have?
You say in your opposition you're concerned about the request being overbroad, but it sounds like you haven't been willing to speak with Ms. Reed's attorneys about narrowing it.
Your Honor, that's not an accurate portrayal. We've had extensive conversations with Attorney Rosenberg regarding a barrage of requests. Actually, I mean, since the pendency of this motion, we actually got issued another subpoena and a draft motion to compel from Attorney Rosenberg. And really, he keeps downplaying or obfuscating the subpoena. It's extremely broad. Our entire conversation with Attorney Rosenberg, we had multiple back and forth emails and communications seeking that he wanted to that the scope was simply about the current investigation and investigation materials regarding Sergeant Goode. The moment we get the subpoena, however, it's this extremely broad request for a myriad of records completely unrelated to the current investigation. That was in part one of our frustrations with the request, is that we're blindsided by the broad nature of this request. It wasn't a good faith effort by Attorney Rosenberg at all. I'd also highlight to the court's observation that, requests 1 and 2 are not only extremely broad as they cover all aspects of discipline, but also it's not just limited to disciplinary records. Defendant's counsel is seeking all records, communications regarding any discipline. So it's not just physical copies of records of discipline, which, again, if that was simply the request, frankly, most of those would be a matter of public record anyway.
Why didn't you produce them? Why didn't you talk to them? Frustration is not a valid reason for me to deny a motion to compel.
You gotta love this, Judge. Just because that old dapper David there from the town of Canton is frustrated with the vast request by old Rosenberg, he still hasn't produced any documents. And the beauty of this argument is that Rosenberg already said, hey, if you really feel like this is going to be something that needs to be within a confidentiality agreement, we'll do it, even though we're not obligated to do so. And that puts the pressure on the town's attorney and this old judge to now make sure that these documents and information are going to be produced.
If you would produce certain things, why wouldn't you talk about what you would produce and try and narrow the areas of disagreement?
Because it seemed clear that wasn't going to be productive.
Well, tell you what, we're going to see whether it's productive. I'm going to give you a chance to do what you're supposed to do under the rules. And while you're doing that, I'm going to ask you talk about this barrage of correspondence. Submit all that correspondence to the court so I can take a look at it. When can the two of you get together?
I can talk this afternoon. I'm happy to.
I'll be available. I have availability Thursday or Wednesday.
Why don't we reconvene this particular discussion next week sometime? All right, we'll see you on the 14th at 3 o'clock.
And there you have it. The judge mandated that dapper David with his beautifully groomed eyebrows and old Attorney Rosenberg get together, meet, and figure this out before they come back at this next hearing date. But no matter what the old judge decided today, we will never, ever stop producing these videos until the real killer,
Brian Higgins,
is brought to justice.
the defendant, kissed me.
How did she kiss you?
Not like a friend.
Lip to lip, is that fair to say?
Yes.
And what was your reaction to that?
I was taken back.